Hello, my name's Taylor Moore. I'm a senior associate at Gomez Law. In law school, I was number one in my class in property law, banking law, negotiable instruments, contracts, and several others that aren't really relevant to property law. But that's what I've been doing for the last 20 years. And I know out of all the firms I've worked at in my career, this is the least stressed firm I've ever worked for as far as the anxiety level for the support staff is low. You know, I've been at firms where like the paralegals are out in the hallway like smoking cigarettes and so nervous. But here at Gomez, you know, this is simple law to us. We've done it a million times. We know how to do it. We know we're not clairvoyant, but we know what's going to happen because we've done it just through experience. Well, when I first moved to Los Angeles, I was looking at different property firms, and Gomez Law does the exact type of property law I've been doing for the last 20 years. Also, a lot of my family's Gomez, randomly. My Aunt Boo married a guy named Jesse Gomez and had a bunch of children, and they had a bunch of children, so our family reunions are mostly Gomez. No relation, but it was kind of felt like a connection that I wanted to pursue. I like property law because for me, property law is like math. You know, there is a right answer. I just need to know all the facts and I can tell you how it's going to work out. And also property law, I don't know if I can say this, but property law is where FU money, you know, we've all heard FU money. Property law is where FU money stops because you can't treat people that way. And we have statutes and regulations that affect this and you can't buy your way out of it. And you can't intrude on other people's property. You can't cross their boundary. What's my real property is my property. You know, we do this for a living. So, you know, for 20 years I've been doing trial after trial. My adrenaline doesn't go up in court. This is just a day in the office for me. But I know for clients it's not like that. I mean, this is a lot of times the biggest problem you've ever dealt with, and it's stressful. And stress can kill you. I've had a client drop dead from a heart attack in the middle of a case, and it was just from, you know, the stress will weigh on you. So my advice is to drink lots of water, take care of yourself, understand that this is a marathon, and to get justice, although the wheels of justice turn, they turn slowly. And so you have to be prepared for that, and also keep a journal of everything that's happening because you won't believe how much stuff you forget. When you get on, you'll just go blank at trial and you can't remember all the things that they did to you. But if you kept a journal, you'll go back through it the day before trial and be like, oh, I forgot about that. And then you'll be well armed and well, you know, prepared and give the best testimony you can give. Partition actions. Now, partitions, the remedy of partition is one of the oldest remedies we have in the law of property law. I mean, I think it's been found in Justinian's Digest back in the Roman times. And the theory is if you're a co-owner with someone and you don't want to be, you don't have to be. You can partition it. Now, back in the day, they would draw a line through the middle of the property saying, you know, like siblings that didn't get along. You got your half of the room, we'll take this half of the room. But with now, in modern times, we do it pretty much always by licitation, by sale. You get an order for sale, you got your real estate agent comes in, lists the property, and then it sells to the highest bidder, and you divvy up the proceeds according to ownership percentages. Everybody can have a Coke and a smile, move on with their lives. And that's how we get property back into the stream of commerce when like a parent has died and we've got 10 siblings, everybody claims a part. It's like, let's just partition it and get this ball moving. You know, the best way a client can help their attorney is doing the homework the attorney gives them. As far as like, give me all the documents together, give me all the deeds, give me all this. Anytime you save the attorney time, you're saving yourself money. And also, the more you can do all your correspondence with the other side and the attorney in writing, you know, because things get lost in translation verbally. And if you can get the other side to admit it via text, well, that's a smoking gun. But if it's just us saying, well, he said that, it's not as powerful as something in written word that we see. So keep them texting, keep them doing emails, and try to limit the amount of oral discussions you have with the other side. I think the most important part of the attorney-client relationship is honesty. Because as your attorney, I want you to win everything. I don't really care about the other side. I just want you to win. But if you're not being honest with me, if I don't know all the facts, I don't know how to protect you. A good example is this is the first case I ever lost. I haven't lost many, but the first trial I ever lost. The client had told me that the defendant had said something to her. It was a crucial piece of evidence in the case. And she swore up and down he had said XYZ to her. When I had him on the stand and started questioning him, it was clear that he had never said that. I've cross-examined hundreds, maybe thousands of defendants at this point in my career, and I can tell when someone's telling the truth. And he was telling the truth. He had never said that. I asked for a recess, and I talked to my client, and I said, he never said that. You said that he had been saying that. And she said, well, someone told me he said that. Oh, man. And she said, what does that mean? I said, that means we're about to lose, and we're going to lose big time. Because the crucial fact that I had been basing the case on wasn't true. So you have to be just honest with your attorney. To a fault, just tell him everything. Because I can deal with facts I know about. I can't deal with facts I don't. Collection of judgments. A judgment's a piece of paper, okay? Suitable for framing. You can make paper airplanes out of it. If you're in a pinch, you could tear it up and use it for kindling and for a fire. You get my point. It's just a piece of paper, unless you can turn that into money. And how do you do that? You do that through execution, garnishment, levies, and such. I mean, there's a lot of different ways to get your money, but the main way we do it is through garnishment and levy. Garnishment, the sheriff goes to the place of employment, serves them with the garnishment. Now they have to pay. Like they owed you money, they have to pay us first, right? Writ of execution on like a bank account, that's probably the best way to get your money. It's like lightning striking because you never know if the defendant has money in their bank account or not because of the different regulations. There's not a lot the bank can tell you. But if you know that they have money or they bank in this place, you have the sheriff levy on that bank account, and then it's yours. You know, to the amount of judgment, it'll take all that money out and you get it. The other more, the nuclear option is seizure and sale of assets. And I've done that a lot, where the defendant's not paying the judgment and you seize their property and you sell it at the courthouse, front steps of the courthouse. I mean, really the biggest mistake I see clients making is just not getting an attorney involved early enough. I mean, what I see is you either pay for an attorney on these complicated deals, you either pay for an attorney in the front end or you really pay for it in the back end. You know, so getting an attorney involved early. Not necessarily you need him to do a bunch of work, but let him be aware of it. Let him know what's going on, because he might see pitfalls that you're not seeing and help you, navigate that before a problem even arises. The most crucial thing you need to remember really is that if you're the plaintiff, time is not your friend. The statute of limitations will erase any claim you have, depending on what it is. Now, if it's a contract, written contract, you got 5 years. If it's a car accident, you got 2 years, things like that. But you need to bring your claim within a reasonable time or you'll lose it forever. So if you have a claim and you haven't had an attorney review it, at least get them to review it and know when your statute of limitations runs, because it'll be time to put up or shut up, and if that time passes, it's over. My favorite story about collecting a judgment, I had a guy, this was a while ago, this was about 10 years ago, I was in Springfield, Missouri, and this guy was a total crook. We had a judgment against him for about $200,000 for fraud, which is important because you have a judgment for fraud, that's not non-dischargeable in a bankruptcy case. You can file bankruptcy all you want, but that claim, that judgment will survive it because it's fraud. So this guy had filed for bankruptcy. He couldn't get our debt discharged. And I was able to see all his finances. Before he dismissed his bankruptcy, I got to see his underbelly of all his dealings. He dismissed the bankruptcy and then he just disappeared. I mean, he was off the grid. We couldn't find him. I recorded the judgment in different counties in Missouri where I knew he had family. And we sat back and waited. About a year later, his uncle died. and his uncle left him the family farm. But he didn't leave him the family farm. He left us the family farm because I had recorded that judgment, which was a lien on that piece of property. As the moment that that uncle died and gave it to his nephew, judgment debtor, our lien attached. And I called the sale. We're at the front steps of the courthouse. I was like, for the non-payment of debt, we were going to. I had a bunch of farmers with like bags of money ready to buy it, and the guy showed up to the courthouse with a certified check for $200,000 and gave it to me and said, stop the sale. And that was powerful. Adverse possession. Now you've heard that possession is 9/10 of the law. That kind of applies a little bit. Adverse possession is the way we resolve claims. And back in the day, like in the Wild West, people would just camp out, find a piece of tract of land. This was the Wild West, right? And you just put a fence around it, and you said it's mine. Well, what if that was owned by someone else? Well, then it's owned by someone else, and I've lived like for the last 10 years raising my family here. Adverse possession comes into effect because continuous, uninterrupted use, open and notorious under claim of right for 10 years, you get the right to that property. You get the ownership of it. So that and it applies to easements too. I changed the law of easements in Missouri. And the way I did it was, I'd never had a trial go so well. We had a big corporation just trying to bulldoze all these trees in this woman's yard, and they claimed they had an easement on their property. They had an easement through adverse possession because someone had used that pathway for 10 years continuously, uninterrupted under claim of right. So they definitely had an easement, where a right of passage through her property. Problem is they didn't use the easement for 10 years, more like 20 years. And there were big oaks growing through that pathway. We could tell because they cut some of them down, and you could count the rings of how many years that tree had been growing there. And the law in Missouri was once you obtained an easement, you couldn't lose it through non-use. That wasn't the law in Louisiana. But I had moved from Louisiana to Missouri, and I imported that law, and I made the argument to the Court of Appeals that should be the law in Missouri as well, and they decided it should be. So although they had the easement, 10 years of non-use, they'd lose it. And so they had no claim. They had to pay my client a lot of money. And that's the case of Castro versus Buckner in I think the U.S. Second Circuit Court of Appeals. Problems with your landlord. The first thing you got to do is look at your lease. All right. Now, leases, rental agreements, these are a creature of statute. The statutes set the floor of what you can do. Right? So I'm going to rent this property to you, $100 a month. Deal. Shake hands. That's a lease. It's an oral lease, and it goes month to month. And as long as they make that payment, that's a valid lease, and the statutes set all the rules as far as what the rights and responsibilities are between the tenant and the landlord. A lease changes all of that. With a lease, you're Neo in the Matrix. You can make it any way you want to within the bounds of legality. You can't lease something to do a criminal enterprise. But you can make the lease however you want to, and you can vary from what the statutes say. You can change the results that would be. So you got to look at your lease first and see if the landlord's done that. Okay, so you've been wronged. Someone breached a contract, or someone's saying that you breached a contract. What do? The first thing you got to do is get an attorney involved. Let them look at it, let them review the claim, and so you can get an idea of what your exposure or what your liability or what the other side's exposure would be. Yeah, so the truth is, right, this is all the facts. This is what happened, okay? This is what is admissible in the court of law, and this is what the judge remembers, right? So you've got to focus on the key issues, the facts that matter. All this other peripheral facts that aren't relevant to the case, that's where an attorney can help you figure out what facts are crucial to the case and what the pathway forward should be and how to prepare.